Welcome today to another edition of Ask a Lawyer Live. I'm David Brannen. We'll be talking today about what are we talking today about? Oh, being fired when you're quote unquote not a good fit. I'm going to talk a bit about that. I've got some other topics to discuss too. Hopefully, we'll have some questions today from some of you who are going to be watching and participating. I'll also check in on our disability claim forum, see if there's any questions there I can answer. Other than that, hoping just for a chill into the day here. Today's my last day of doing this for a while. I'll be taking, the next few days off. I'll be back next Tuesday. So in the meantime, I hope you have a good I wish you guys all the best. So let's dive in here on today's topic. So, what does it mean to be fired when you're told you're not a good fit? On the surface, this can seem like a very polite way to end things, but as you'll see, this is kind of a vague reasoning, can sometimes hide deeper legal issues that you should be considering. And knowing what to watch out for in these kind of situations can help protect your rights. Or if you have a friend or family member who may have been fired for being not a good fit, these are some of the points you could bring up with them. Let's dive in here. So, what does it mean to be not a good fit? Well, what does this phrase actually mean or not mean? It's a subjective explanation that employers often use when they don't have specific reasons. It might mean they don't think that you fit in with the culture, or your personality clashed with other people, or your work style didn't really mesh or align with theirs. In other words, it's like kind of vague by design. By saying you're not a good fit, obviously, it could just mean that they're trying to avoid conflict or to avoid revealing the real reason that you're fired. Now, just keep in mind when you're let go or fired or terminated, dismissed, whatever word you want to use, the employer does not technically have to give you a reason why. That's why it can sometimes be odd for them to use the wording not a good fit. I would if I was advising an employer, I would tell them never say those words because it does open the door for all kinds of potential problems. Now, when does it become a problem? These are some of the problems that I would say employers should try to avoid. Now, if someone is fired, like if they fire you shortly after you've made a request for medical accommodation or you've been on a sick leave, saying that you're not a good fit can suggest that there's a retaliation or some type of discrimination going on. So, really not good for it to be used in that situation. And that's where I've commonly seen it used. Now, the employer may or may not have meant to link it to discrimination, but it's certainly that is kind of what you're looking at when you say that someone's not a good fit, when you're firing them for coming off a medical leave, asking for medical leave, this kind of thing. Now, it's also a problem when it's used during or after probation to avoid severance obligations. So if a contract doesn't clearly define a probation period and the person has been there longer than 3 months, they still may be entitled to notice or severance. So just keep that in mind. And in some cases, fit can be a convenient way of masking like an underlying bias based on race, age, disability, or other protected grounds of discrimination. That's the real problem that lawyers can run into here if they're not careful. Now, let's move on to the next slide. Now, if you are fired and told that it's because you're not a good fit, that does not mean that there's anything wrong by the employer. You still, even though you're being fired for not a good fit, it doesn't mean that they've had just cause to fire you. Just cause terminations mean that you've done something so bad the employer doesn't have to pay you any termination pay. If you've been told that you're just not a good fit, that would be considered a without cause termination, and you would be entitled to proper notice of severance pay, either under your contract or the bare minimums allowed under the Employment Standards Act or in common law in your province. Now, you might also, in addition to severance pay, have a right to a human rights complaint and compensation under the Human Rights Act of your province as well. And if the employer is hiding behind fit to downplay the real reason, like a personality conflict, you may be owed more than what they've intentionally offered. It is improper. Like employers do not have to give a reason for termination, but they can get into trouble. It can be considered an aggravating factor if they are giving false reasons for a termination. So, what are some red flags that you can look out for? Again, The big red flag here is going to be timing. If you're fired right after taking a medical leave, making an accommodation request, a workplace complaint, disclosing a mental health issue, then obviously it's suspicious. And if they say you're not a good fit, that just may be a way for them not being able to try to obscure the real reason here, that is the protected ground of discrimination. So another red flag, in addition to timing, there can also be inconsistency. So if the reason of your dismissal changes depending on who you talk to, et cetera, or nothing, they're not putting anything in writing, that's a sign the employer may be trying not to disclose the real reason that they want to let you go. So what to do if you're fired and then you're told it's not a good fit? The most important thing when you're fired is never to, like, we had an example today where someone was let go and they kind of left the room giving everyone the finger, refusing to take the documents, that kind of thing. So you don't want to do that. You should stay calm. Don't argue or get defensive. You'll have your chance to give your response later. It doesn't help for you to blow up or make a scene or tell people off in that situation. Even though that might feel good in the moment, it doesn't help your case legally. You should ask for the reasons for termination in writing. They may refuse to do so, and they don't necessarily have to give you reasons, but it doesn't hurt to ask. Get a copy of your record of employment as soon as it becomes issued. They should be issuing that within 5 working days. They'll have to put a code on it, and the code on there can give you some insight into the reasons for dismissal. Now, unfortunately, the code for dismissal for cause and without cause, it's the same code, so you can't really tell by looking at the code itself. The Service Canada would do further investigation to determine if it's a with cause or without cause termination. Most importantly, don't sign anything without legal advice, especially a severance offer. You may feel pressured to do so, but it's improper for the employer to put pressure on you to try to force you to sign a release or a severance package without allowing you time to get legal advice. If you sign a severance package under those kind of conditions, often we can get those overturned. So just keep that in mind. And you do want to start gathering documents that support your side of the story, performance reviews, emails, internal messages, etc. Just be careful not to take any documents that would be considered proprietary to the company. These steps can make a difference in protecting yourself, so just keep that in mind. All right. Now, probationary employees, so people who are still on a probation, usually within the first 3 months, it could be longer, but for 3 months you would be on a probation period for most new jobs, unless the employer waives it. Can go for longer. If you're having a probationary period, it does need to be mentioned in your employment contract if it's going to be longer than 3 months. Human rights laws, this is important. We had this case come up today, and a potential client we're going to represent, that human rights laws still apply during your probation period. So just keep that in mind. You can be let go during your probationary period without any real reasons given, but it can't be for a discriminatory reason. So if you're terminated during a probation period and you think that it could be the result of against a protected ground of discrimination like disabilities, the common one we see, then you have rights and you should talk to a lawyer in that situation. All right. There we go. Sorry, I forgot to go ahead there. Now, final thoughts are, what are my final thoughts here? So being fired for not a good fit, it may mean nothing at all. It doesn't automatically mean that there's anything wrong, but it also it can be a tell that there are other things going on. So it will often be used to mask a situation where there is discrimination, and that could be the grounds of why they're saying you're not a good fit. It's kind of like a Freudian slip in some situations, because they're saying you're not a good fit for discriminatory grounds is where they get into trouble. Now, you don't have to accept that, any severance or anything that's offered to you immediately. Get legal advice and determine if you're owed more than what's being offered. Again, employers are allowed to terminate you for any reason as long as it's not a discriminatory purpose. So that they don't have to give you reasons for the dismissal, but it is a bit of a red flag if they say that the reason is that you're not a good fit. All right. Now, what if you call us over this, what to expect? You will speak to someone on our team. We have two people, great people on our intake team who talk to anyone who calls into the firm looking for legal advice. That's the first step in the process. They gather basic information and can answer basic questions. They take, if you're interested in going further with it or getting legal advice, they take your information to our legal team and then we review it daily. We review these cases and they can come back to you with what our legal team can do for your situation. Sometimes they may recommend you get a more detailed legal consultation. Often we have to do those on a paid basis. Or if we can take your case on, they will let you know. And that's the process that people use to hire us. Not everyone has to hire a lawyer. Oftentimes, like most of these that we review, we don't recommend them hiring us and we just give some advice on what they might be able to do next. Sometimes we can't give advice at all, but it still is good to call into a law firm and to get some idea of what your options are. All right. Let's see if there's any questions. So no questions here yet. There are some other things that let's move on to this page here. There are some other topics that I did want to cover here. So just the business of being terminated during a probation period. So let's talk about that a little bit. I'll put up a little banner here to talk about this. Can't type. Employment termination during probation. All right, let's just do that. So let's talk about this a little bit. It's interesting because we've got two cases right now where I'm representing people where this is an issue, and I won't go into details on it, but actually, no, I'm not. There's one case that we're dealing with. There's a case I did a while back, and we did some legal research on this issue just because we were thinking of taking on this case. I don't know if the person hired us or not, but the thing about probation periods is you still have rights. Now, a lot of time, the amount of severance you can get is tied to how long you've been at a job. So the problem in many situations, if you are terminated during a probation period, you've by definition been there not that long for most cases. So typically that is a factor that would say you're not entitled to much for compensation. However, there are exceptions. So keep in mind that even if you are terminated in a probation period, you still may be entitled to significant amounts of money, particularly if you were kind of recruited into this job and left a stable job and were recruited away, like enticed to come to this new job, and then they fire you. That is something that you should know, that it can result in greater damages than you might think, because the fact that you were enticed away, even though you've only been there a short period of time, you are suffering. They kind of enticed you away from a stable job into this new job, and now that you've been fired within 3 months, we can often that's the type of situation where you can get more for your termination pay and compensation than might otherwise be indicated by the short time. The other thing to keep in mind is you can't be, even in the like I've already discussed, even in the probation period, you can't be terminated for discriminatory reasons. In fact, there's a important case, I think it was out of Ontario, where somebody was terminated during the probation period, and the Human Rights Tribunal determined that it was the court, I can't quite remember. They determined that it was for discrimination based on mental illness, and they awarded quite high damages for this individual. So they got a lot of money, even though they had only worked there a very short period of time, a matter of weeks. But because they were terminated for discriminatory reasons, the court awarded a significant amount of human rights damages for that case. So it's not true. Just keep in mind that you do have rights during the probation period, and you should not assume that you have no rights. Another case I worked on was the employee was recruited to come to a job. They had to move across Canada. They incurred a lot of expenses. They actually negotiated that the probation period be removed, which was confirmed in emails back and forth. and but the final contract didn't was kind of silent on it. It didn't say there was a probation period, but it didn't say there wasn't. And so after the person was terminated during the probation period, the employer attempted to rely on it, and we pointed out that this was something that was negotiated, and we would be relying on the email correspondence to argue that the probationary period was removed. So just keep that in mind. That case is ongoing, but that is something to consider when looking at a case like this. Is there other evidence that the probation period has been removed by either side? All righty, let's take a peek at our. Let's go over and take a look, see if there's any questions over in the disability forum. This is a forum that I moderate. I own the website and I do moderate it. In fact, I've never moderated it better than since I started this daily live stream, because we're on it every day and I got you folks here helping me answer the questions. So let's look at this one. Going back to work after LTD of 6 years. So I think this is one where I gave some information here the other day. So what I had said yesterday on this one is it's good news that you want to give returning to work a try. You may have an opportunity. When considering something like this, you want to be upfront with both the LTD and CPP. You want CPP disability to put you on their VOC rehab program. Most group insurance policies do have a reoccurrence clause. So this person wanted to know, like, if they try this return to work and things don't go well, can they go back on LTD automatically? And the answer to that is, as we'll see down below here, is maybe. I told them that they would have to really read the section of their policy that talks about reoccurrence. Sometimes the reoccurrence has to happen within 6 months, but there are group policies that will not allow a reoccurrence if you go back to work for some other employer other than the one attached to the insurance. So this person replied and said, "Thank you, David. Are insurance companies obligated to provide the group policy when it's specifically requested?" That is a good question, and I do need to double check on. I should just figure this out at some point. What? Let me just see if I can find it here now. Most provinces do not require a group insurance company to provide the group members with a copy of the policy, but some provinces do. So if you're in Ontario, there is a requirement for them to provide a copy of the group insurance policy under the Insurance Act. Yeah, so it looks like it's Ontario. So I'm just looking at my notes here. It looks like it's Ontario, Quebec, British Columbia, and Alberta. Yeah, Ontario has the biggest protection. So I'll respond to this person and say it uh, what was the other one? I think it was Manitoba, is it? No, it's just those three. Okay. So those they require the insurer sure to there we go. So we'll give this answer. I don't know if you guys can all read that or not, but basically, Ontario has the biggest protections. They do require them to provide a copy of the policy, but in other provinces, like then there's BC, Quebec, and Alberta, all require a certificate, and other provinces have much weaker language. So a certificate just means a overview of the benefits. It's often what you need, but all right. Looks like there's no other new questions here. Okay, we'll leave it at that. Let's see what else I got here. I had some other stuff I wanted to cover today. No, I think that's pretty much it. Those are the main things I want to cover. Yeah, it was mostly around the termination, this idea of them saying you're not a good fit. Most employers want to avoid giving reasons for termination because it just doesn't help them to give a reason, quite honestly. Even if they say things like we're restructuring or these kind of things, if they say that and they're not actually restructuring, it just causes more problems from them. So unless they are actually restructuring, they're better off just not giving a reason. And it does protect them from by not giving a reason, it's harder for you to like make out that there's some it protects them from like discrimination or other types of things if they just keep it vague on why they're not letting you go. It doesn't affect your rights. You still have a right to reasonable notice or pay in lieu of the reasonable notice. In lieu just means they can either give you the notice so they can say your job's going to end in 6 months and keep working in the meantime, or they can say, we're letting you go today and here's your 6 months pay. Those are the two types of things they can do. Now, most employers are not going to pay you 6 months pay. They're going to say, here is here's like 3 weeks pay based on what the minimum required under the Employment Standards Act. And if you go do your research online or you talk to a lawyer, you might learn, oh, you could be owed up to 6 months pay because you've worked there for 7 years or 8 years or whatever. And then that's when you have to start looking into the situation. Like, does your employment contract prevent you from getting common law termination pay up to 6 months? That'd be the first thing you'd want to know. The second thing you'd want to know is like, are there any other factors that might extend it longer or make it shorter than that? But often the question is going to be, is it worth your while to kind of go after the employer to try to get more money than the bare minimum that they're offering you? It's often a harder decision than it may seem. Like getting a lawyer sometimes can work pretty quickly, but often it's not financially practical to go after the employer and sue them depending on how much more money is owed. And they understand that. That's why they often will lowball people. So the best thing you can do in these employment situations is just get legal advice, do your own research, get some legal advice, and figure out, does it make sense for you to kind of go ahead with the lawsuit. All right. All right, folks. It looks like we don't have any questions today, which is fine. I have to finish up some work this afternoon and tomorrow. Then I'm going to be away from work for a few days, which is great. I'll be completely off the grid, and I'll be back next week. Like I said, I'll be back here next Tuesday. I do wish you folks all the best, and I'll see you then.